They're there. Yes, sir. On the record.
Recording in progress. This case number 11004. People have Junior Lewis Morrison. Your Junior Lewis Morrison during the jail by video. Right. Mr. Morrison's attorney is Jake Wagner. This hearing being conducted by Judge Wagner Gray. His office, attorney Collins, representing the state, Director office, also office information attorney. He was convicted of illegal offense of drugs and abuse on the grounds of a specified governmental facility at 33 felony back on September the 7th, 2021. There's a notification filed on 11/17 that the defendant had likely violated the conditions of Rule 7 and that he had failed drug screens, THC, or amphetamine, and or methamphetamine. 9/26, 10/23, 11/14, 21, reviews of drug screen, 11/13/21. And then on Rule 19, he approved the criminal treatment facility from all failed drug screens, fusing to attend groups, each of which having pornographic material on his cell phone. That was signed by Officer Kelly on 11/17/21. The court notified Mr. Morrison of his the alleged violations. The matter was set for an evidentiary hearing today, where Mr. Wagner was representing the defendant. And Wagner, you had an opportunity to review these allegations of Morrison.
I have, Your Honor.
And when we have a hearing, or
yeah, we would admit to. I apologize, sir.
That's right.
We would admit to the violation, Your Honor.
All right, now, Mr. Wagner, you and your client are both agreeable to this hearing being conducted by Zoom rather than in person.
We discussed that, sir, yes.
All right, you're all right with that, Mr. Morrison?
Yeah.
All right. So, Mr. Morrison, you were convicted of a third-degree felony, which carries a possible prison term of between 9 and 36 months in increments provided by law. In the event that you are found to have violated these conditions, I could do one of three things. I could continue committed control, the same conditions, continue with additional conditions that are appropriate. But the third, the most serious, I could continue or revoke it in prison for between 9 and 36 months. Now, do you understand all that?
Yes.
All right. Do you understand your right to have a hearing?
Yes.
Stand the witnesses from the state. Could I ask everybody to mute their mics if you're not talking, because I'll get some feedback from somewhere. Not you, Mr. Morrison. Ben, you might need to mute the one in the courtroom.
Okay.
I think that's the one noise is coming from. I think we're getting some feedback from the speaker. Violations, alleged violations?
Yeah.
Alright, and do you admit them?
Yeah.
Okay. I think from the basic department or the state regarding the disposition. Okay.
Yeah, at this time we would ask the court to revoke the defendant's community control in order to be incarcerated.
I'm not quite sure how to articulate what I'm about to say here, but I met with my client when I first saw the violation. I got you, because I mean, the truth is what it is. He got a break, now that cuts against us in this case. This 30-year probation stuff and that out, probation for Turtle Creek. And the troubling part to me was the underlying crime was smuggling drugs into Greenfield jail. Now here we are, he had a facility, he had drugs, obviously positive test, which I feel is the underlying issue here. And recently speaking with him, kind of taking the legal argument out, I kind of looked at him and just dumbfounded, asked him what the world was thinking. His reply, paraphrasing my words, is, it's not an excuse, let me say that coming out in the very beginning, but it was kind of sobering to me. He said that drugs are all over this campus at Turtle Creek. People were bringing it in, they're receiving treatment, it's everywhere you turn around. Again, I asked him, it still doesn't justify or explain to me why in the world you use these things. I guess the only thing that I can offer the court is Junior, from his description, suffers from depression, had a really tough time in there, and the only thing he could turn to is drugs. And again, that's not an excuse. He knew what was staring him in the face. I guess what I grappled with, Your Honor, one of the goals we have here is maybe trying to rectify this situation. I understand there's still punishment that must be accounted for to deter this kind of conduct. But if underlying depression is what we're obviously dealing with here, and drug usage is his only term, sitting in the prison, I don't know, maybe it's not what we're going to fix him. It's not going to solve anything. I know we're limited on what he can do because he is a registered sex offender. I don't know if the court's willing to take a risk and look at other alternatives that are out there. See if Turtle Creek can take it back. I don't know if he's a candidate for drug court. Again, we understand he got a break. It's just, and I'm being very nice to Junior. I think there's probably some other mental health issues, maybe some learning disabilities. I'm not sure, but it just, if he has depression, if he has mental health issues, and this is what he turned to, we're never going to fix this problem. We're going to see Junior not 12, 16 months down the road when he's back out again. I guess we're asking the court if they find it appropriate to give him one last shot, Your Honor. I know the court is gracious enough to give us one. The state was gracious enough to give us one. Based on the recommendation report right here.
Carson, anything you'd like to say?
I messed up, and I'm willing to try and restart the program for free. Allow it, and they said, you got the money, so I'd like to do that. And like the finally said, I'm doing precedent and stuff now, and if I do have an excuse on the slow number each day, and I was going to a lot there, and the only thing I had to get away from all that was use. It was like he said, it's all around it there.
Mr. Carson, was any indication in the recent report that ever been treated for any mental health issues? Have you?
Yeah, so learning classes in my phone for office, 5 minutes as a slow learner.
Did you graduate from Beaver High School? Beaver, though, I don't think, right?
Yeah.
And Officer Kelly, when was he removed from the Creek facility?
No, Your Honor, he was removed on November the 17th.
Did they basically terminated him?
Yes, Your Honor. And then a staff coordinator emailed me like violations that they're on a point system and he exceeded the points. They asked that we come and make pickup on him that he was being removed.
Mr. Larson, the trouble, and even if Turtle Creek will send you back, it sounds to me like the only reason you're going back there is so you can get back in drugs again, because as you said, they're all over, and that's why you got in trouble, because, you don't have the willpower or the desire, apparently, not used. And the thing is that, you know, your attorney said, you know, well, if we want to fix you, well, we can't fix you. You have to fix yourself. We can offer you opportunities and tools to use to try to fix yourself. But it all comes down to you and no one else. And the other thing that bothers me is that in addition to passing drugs, you were also refusing to go to classes, in coordination, uh, and refused to do your chores. And apparently they let you have a cell phone down there. I didn't know that. But what I know now about Turtle Creek, I don't look like probation, that's the last time I'm going to use it. I think we'll use it out of fact that was the only place to take sex offenders. Which also was one of the reasons we couldn't push it to the drug court. And it had pornographic material on your cell phone. So, based upon that, it supports the determination that you are not sincere about doing anything with your drug problem, and that you're just basically wanting to try to stay out of prison and continue to do what you've done. And so, as a judgment of the court that you're being controlled, be revoked, court finds that you've not been amenable to control supervision based upon your conduct and refusal to discontinue the use of drugs and participate in what's supposed to be a treatment and rehabilitation program. It's a judgment order of the court that you be sentenced to the Correctional Reception Center in Morelia, Ohio for a period of 18 months. Then you have a jail time credit sheet there in the courtroom.
Yes, I do, Judge.
Need to unmute you. No, I can unmute there, man. I can't unmute you. I can mute you, but I can't unmute you.
Can you hear me? I do, Judge.
How many days?
13 days.
19?
13.
13, all right. 13 days, all right. And let's see, the Turtle Creek facility is not a lockdown facility, is it, Officer Kelly?
No, Your Honor, it is not.
So the 13 days of jail time credit, yes, that's that. Now, upon completion of the sentence, Mr. Morrison, it is possible that the adult parole authority will place you under post-release control for a period of, see, is this 3 years, Mr. Collins, or 2?
Oh. According to the plea form,
Well, this was under the old law.
this is under the old law, so it's 3 years.
Okay.
Or, well, yeah, it's at 3, so it's 3 years under the old law.
3 years, all right. So it's possible to be put under post-release control supervision for a period of 3 years by the adult parole authority. If they do that, you'll be supervised on the terms and conditions they set. During that period of time, they determine that you will comply. They can return you to prison and make a certification period of up to 9 months for 1 or more violations. That would be the cap. However, if you commit a felony, then an additional whatever sentence the judge in the case can impose upon you, the judge is also authorized to sentence you in this case for committing a violation while under post-release control with an additional period of 1 year, whatever time might be left out the period of post-release control, whichever is greater. That occurs, that must be served consecutively sentenced. We also order to pay the court costs for judgment, grant, and execution's order. If we fail to do that, then upon completion of your term, while you're there, or can order you to do service, give you credit for each hour you work, reduce your judgment by that amount. All right. Is there anything further, counsel?
Hey, John.
All right. We'll be hearing that thing. All right, Ben, I think we have a separate invite for the next hearing. Is that correct?
Yes, sir.
All right, thank you.
Is this Sierra Newcomb?
Yeah. All right, Ben, we'll go ahead and go on record.
Yes.
I'll put you on mute.
Yes, sir.
All right, this is case number. Okay, I don't think I'm the host, Ben. I can't mute you there. Would you go ahead and mute that?
Yes.
208, State of Ohio versus Sierra Newcomb. Your Sierra Newcomb appearing there on the screen is Mark Steve Graham.
Yes, sir.
All right. All right. Ms. Newcomb was convicted of aggravated possession of drugs, 50-year penalty, placed on pre-control, July 7, 2021. Now, Ms. Grimm, there was a habeas issued for you on July the 16th, 2021, because you had failed to report to the High County Probation Department, and you had been removed from the Racing for Recovery Treatment Center. And apparently, we called, my staff received a contact from you or something, and so we set this matter for hearing today. What's your current location?
I'm at West Central CBCF in Marysville, Ohio.
Okay. And you're sent there by Logan County?
Yes, sir, on July 18th.
All right. All right. Well, you are still required to contact the probation department. You haven't done so. That's why we have a warrant.
Sir, I have tried to contact that probation department since the day I got out of court when you sent me on the I left a message with Andy Fulton. I tried to call Eric or Majima. The receptionist I never could get through to. I have called faithfully since July.
Well, somebody would have answered the phone at some point. Ms. Kelly, have you received any messages from her?
Your Honor, on July 21st, she called and left a message with Mr. Armagina. I did try to contact her back. However, we had no way to get a hold of her because she has never even been in to sign her conditions. Therefore, that's when we filed the KPS on her whereabouts unknown. Then she did contact back in October while she was at West Central. We've been going back and forth with the case manager advising there was a KPS and that the only way that it could be resolved is for her to turn herself in or when she completed treatment to come and turn herself in.
On July 7th, with me being in Toledo, Your Honor, you told me to call. At that point, I didn't know who my probation officer was.
No, you don't have one yet because you've never reported and done the paperwork. All right, so that is a problem. Now, what we can do, be quiet, okay? You know, this has been a complete hassle with you from day one. You know, you always have an excuse. This is the best excuse you've had because you're in custody. All right, so you do have an excuse. You're there. Now, what I'm going to do is I'm going to recall the KPS, and you give Miss Kelly there the number to call you at so they can set up a Zoom meeting and talk to you, and then they'll send the paperwork out there. But when you are released from the CBCF, you have to report in person by the end of business the next day. So if you're released on a Friday, then you got to report by Monday at 4 o'clock. Not at 4:01. Don't be late because they close at 4.
Yes, sir.
And if you don't get it done then the KP is going to issue for you again. We're going to bring you back. Now,
Yes, sir.
what's a good contact number for you? Ms. Kelly, you want to write this down?
Yes, sir.
937-644-3698.
And is that your case manager's number?
That's the main office.
All right, the main office, all right. Okay. Then, Ms. Kelly can call you immediately after we get done here and set up an appointment for you to go over the paperwork, and get the paperwork to you.
Yes, Your Honor.
All right. Anything further then from the Commissioner of the state?
No, Your Honor.
All right.
I'd like to add in there, the extension is 382.
All right, good. Great. All right.
Thank you.
All right. Make sure you do that.
Yes, sir, thank you.
record.
Yes, sir.
Recording in progress.
All right, this is case number 17-125, State of Ohio versus Douglas Allen Smith. Are you Douglas Allen Smith appearing there from the jail?
Yes, sir.
All right, this hearing is being conducted by Zoom. Mr. Attorney Dennis Kirk is appearing from his office. Attorney Collins is appearing from her office. Also, Commission Officer Smith, Finley is on the call as well. The defendant was convicted of non-support and placed on paid control on January 18th of 2018 for fourth-degree felony non-support. Notification filed that the defendant has failed to comply with those conditions on November the 15th. The defendant was informed of those this year. The defendant was informed of the alleged violation. Counsel appointed representative. The matter was set for hearing this morning. Mr. Kirk will get an opportunity to review his allegations and consult with Mr. Smith.
I have, Your Honor.
All right. First of all, do both you and your client agree to waive his personal presence in the courtroom and conduct this hearing by Zoom?
Yes, Your Honor.
You're okay with that, Mr. Smith?
Yes, sir.
All right. Now, if you need to speak to your attorney at any time during this hearing, just let me know, and I can put you in a breakout room with him, and just the two of you talking. No one else will be able to see you or hear you. All right. All right. The defendant notification alleges that he's failed to report to the probation department since November 23rd of 2020 in violation of Rule 2. Rule 3 is that on 9/17/21, officers went to his last address and he was not, the home was vacant. Rule 7, that on November 15th, 2021, the defendant was arrested by Highland County Probation Department and advised and briefed that he had marijuana on his person. And Rule 20, that he owes $62,850.95 in child support. Last payment made in February of 2021 through unemployment. Now, Mr. Kirk, does your client wish to have a hearing on those allegations, or will it be an admission?
Your Honor, I did go over the allegations with my client. As to Rule 7, he does stand prepared to admit. As to Rule 2, 3, and 20, he reports, and we're trying to check this out. I'm not sure if the probation office can speak to it. He reports that he would not have reported prior to February of this year, but beginning in February of this year, he was in Lebanon, Ohio, at the CBC across the road from the prison, and was incarcerated there in a treatment program that was, he reports, locked down. He advised that he provided the probation department with some documentation as to that. So I guess he would be admitting to the violations, but there is some mitigating circumstances.
Okay. All right, so Rule 2, from November 23rd until the time he was incarcerated, and Rule 7. And what about Rule 20?
The same with Rule 20, he advised prior to February of this year there was unemployment, and he was working as well, and at least he did make payments then. So the payments stopped.
Oh, okay. He went in incarceration then, all right.
Yes.
I just, Ms. Collins, we're able to.
Yes, that is. We would dismiss whatever he's not admitting to.
Dismiss Rule 3 and Rule 20. All right. Now, Mr. Allen, you have a right to have a hearing on these matters in which the state has to present evidence that proves that you have violated these conditions. You can have your attorney cross-examine the witnesses and try to bring out evidence to help your side of the case, and also present evidence on your own. Now, if you admit to these violations, or if you're found guilty of the violations based upon a hearing, I can do one of three things. I can continue your community control under the same conditions previously ordered. I can continue with additional conditions that I think are appropriate, including that's already 5 years. And third, and most serious, is that I could revoke your community control and sentence you to prison for 18 months, fine you $5,000. You understand that? Has anyone promised you anything, and you in any way to get you to admit to these violations?
No, sir.
Right? Do you understand the possible consequences of the violations?
Yes, sir.
Right. If you admit Rule 2 and Rule 7 violations as alleged, then the notification was filed with the court.
Yes, sir.
All right? And Rule 3 and Rule 20 will be dismissed. Now, is there anything from the state or the probation department regarding the alleged violations?
Your Honor, at this time, the state would ask that the defendant's community control be revoked and that he be sentenced to a term of incarceration. Mr. Smith had his dad take some forms, I think, to the probation department, which are a couple of certificates of completion from the Talbert House. They don't have an end date on them. They just, for example, one says successful completion of 68 hours of substance abuse training, defendant's program. No idea when he was actually there. Another one says successful completion of mental health group. Don't know when he was there. That's the same one. 24 hours of vocational training. Again, don't know when he was in and out. During his time on either pretrial supervision, Mr. Smith was extremely non-compliant. When he was sentenced, at that time, he already had, a case pending in Greene County. He was supposed to be working at that time. Your Honor advised him that he had one chance, and if he doesn't have a job, he was going to prison. That was on January 18th of 2018. I'm not sure what he's been doing since then, but as far as I know, there's been $3,000 in restitution paid in almost 4 years. $3,000 paid in child support with restitution in 4 years. It's just unacceptable. Based on all that, we would ask the court to revoke the defendant's community control and sentence him to a term of incarceration at this point.
Mr. Kirk, that is bad.
Thank you, Your Honor. I would ask the court to extend continue community control. In this case, with it being the base charge of a child support case, if he's locked up, he's obviously not going to be paying. In this case, like I said earlier, there are mitigating circumstances. He reports to me that in early February, he can speak a little bit more about this. He entered the CBCF program in Lebanon, Ohio, through Greene County. He stated that he was that it is a lockdown facility that he was at. The Talbert House provided some of the services that were at the facility. He advised that he was there for a period of about 5 months. That when he arrived, he had a case manager. He reported to the case manager that he was on supervision in Highland County. She indicated that she would let Highland County know, and then apparently separated employment a short time later. And the second case manager thought the first case manager had already taken care of things. So there was some miscommunication there with relaying to Highland County what was going on. Also, I think the probation officer switched for Mr. Balzer to the current probation officer during that time as well. So I'm not sure what information was passed along or not passed along. However, he did indicate he was also in a period of unemployment where he received benefits that were taken for child support. Those ended sometime in February as well when he entered the program. So in this case, it sounds like this is his first violation. He went from 2018 until now, and so would ask the court to continue community control at this time. Thank you.
I asked, what program does he allege he was in February?
That's when he alleges that he entered the, I think he called it CCC in Lebanon. It's on State Route 763 across from the prison. It's similar to STAR, he reports.
Thank you.
Hey, Mr. Smith.
Proof of that, Sandy, or anything confirming that?
I have a discharge and case plan here that his admission date was June 29th of 2021. And his discharge date was November 15th of 2021.
Correct.
So from February to April, we don't know where he was.
Can I say something?
Yeah, go ahead.
I was incarcerated in the jail, waiting on a bed date for CCC. My father is en route to get his first office right now with the discharge plan and certificates and all that stuff, because maybe some of those were not copied and forwarded to the probation department. He should be getting at Mr. Kurt's office anytime. He lives in Chillicothe, and he can bring that with him too. Because Mr. Kurt asked me if he could bring this. But yeah, that is correct. I got out on November 15th at 8 a.m. in the morning, and I went in on June 29th. That's correct. But I had a jail term.
What's your charge out of Greene County?
It was drug, F4 drug possession, or F5 drug possession.
Okay.
Your Honor, I believe that Ms. Kelly has checked web jamming to note his dates of incarceration, and she does show he was incarcerated in Greene County from April 13th to probably around June 29th when he went to the Tower House, but nothing from February to April.
Okay. And so basically, you went. When were you arrested again in Greene County?
Well, what had happened, Your Honor, was
when were you arrested in Greene County?
I got arrested in Ross County.
All right. So when did you get arrested on the Greene County charge? And go to jail?
I believe it was like somewhere in the beginning of April. I'm not really sure.
April. Okay.
Yeah.
All right. And the only thing is, go ahead.
There's so much going on here, Your Honor, that I'm, I got all this stuff written down, and it's so confusing. But, the facts are true, I'm not, I went to CCC. It is a lockdown facility. They have a halfway house next door, and I think there might have been some confusion with that. But, I did a jail stint. Like I said, I turned myself into Ross County because I had no way up in Greene County. Then they transported me to Greene County. Or Greene County come got me. And then I did a jail term there, went to CCC and graduated. But before all that, I also was in another jail term, and I don't even know the dates on there.
Where was that?
In Greene County. But it was like in 2020. And so I see here where it says something about, available for probation officer. And what had happened was same thing there, and I put report on, so I had to up there. And what had happened was, I had relapsed, and I had to go get help. And, unfortunately, it's taken all this time to get everything straight. Like I said, my father's able to do his office with my certificates and stuff.
I have your certificates. I've seen those.
Okay, and there's a discharge, so.
I don't have that.
Yeah, well, and that's what I was afraid of.
The Tower House provided the services at the CCC.
Yes, sir. Yep, exactly.
Okay. So what, do you have a job?
I do,
Where?
it's at Superior Carpet in Wilmington. The bad thing about that is right now I don't have a license because it's just me actually living with child support. And I'm moving in with my parents, Chillicothe, which is going to be the best thing because they've never been in trouble with food, drugs, or alcohol. I split up from the girl I was with that actually was a toxic relationship. And so I'm going to get a job, hopefully somewhere around Chillicothe, because my parents are older and I don't want them to have to drive to Wilmington every day. But, I could work there for a couple of weeks to get money up. I want to start paying child support immediately because I have not one but 2 orders of child support. So that has to be paid here and in Greene County. So, I got 5 kids and I'm clean and healthy, and I have to go down community now to work and pay child support. And that's what I want to do. I just became a grandfather last December. I haven't even had to see my grandbaby yet, and just set up life with.
Your Honor, did he just say that he was clean now?
Yes,
Well, you had pot on you when you went into jail.
I did.
It's not clean.
Well, you're right. You see, I had a marijuana card. It expired, and so I wasn't able to have that. Right. And I admit to that. But Sandy Kelly, when I did come to test me, and I was
Yeah, you were clean. Yeah, I do have that.
and she told me if I wanted, I had to get my card again. So, yeah.
What are you getting a marijuana card for besides just to get high?
Because I'm on so many mental health medications that they won't even give them all to me here. It's ridiculous. And
Well, if all those medications are working, I don't know how pot would work. That's just medical marijuana is just another way of being high, and it interferes with recovery. That's one of the reasons that is.
Your Honor, if I may.
Yeah.
This was his third non-support case in Highland County alone.
Yes, I know. Yeah.
And he has done nothing to try to get this remedy.
How many payments were made when he was employed? Do you have that record there, Mr. Collins?
I don't have any. I just know that he.
I know he had a job at the time he was sentenced. That's why he got community control. And then he got unemployment, and then, according to what you said, the agency got some assignments from unemployment.
Well,
and then
I know that
terminated when he got incarcerated.
he was originally ordered to pay $65,707, and now he owes $62,850. So about $100,000.
But I'm just wondering how much of that was paid from when he was employed.
Where was he employed at to begin with?
when I came before he got sentenced, I was employed through a temp service, Marshall County. And there were several payments made up until the sentencing process. I'm not sure how many was made from him. Like I said, because that's when I started looking at it.
All right, anything else?
I'm calculating it if the court wants to know exactly what was paid.
Well, no, I was interested in how many payments were made when he was
I'll be able to tell you that in just a moment. $7.
Okay.
Because his order was $418 a month, and he's only paid just over $2,500 in 4 years.
Okay. Anything else, Mr. Kirk?
One thing I would note is I do hear somebody out in my lobby. It sounds like maybe his father is out there with records. I'm not sure that there's anything more we need or not.
I don't think so at this point.
Okay.
Well, Mr. Smith, you do have a bad habit of not paying child support. This is your third conviction in this county. You have apparently one in Clinton County.
Yes, sir.
And you have drugs. You don't need to speak now. So, the problem here is that you're not doing what you need to do, and then you use this medical marijuana card as a substitute. Because this is a non-support case, I'm going to give you one last chance.
Thank you.
I told you you don't need to speak. Again, don't speak. All right. I'm marking down here. This is your last chance. Now, this case has been going on since January of 18, and since you were, was born out for you for, let's see, looks like from September 7th to 27th, so that's been extended for 2 additional months. So, and I don't know if there's any other time it's told or not, but you're going to become employed and remain employed. You're going to pay support monthly, $400. Pay court costs. Are you supposed to be in any aftercare treatment? Where at?
Right, even with the time.
All right. So you're to remain compliant with your treatment program. And you're not to have medical marijuana. I know that you can allow that, you know, I mean, you know why it's one of the biggest legal fictions in the history of law is that this is not really for medicine. It's really just a way for the state to raise money because everybody in treatment will tell you that medical marijuana, as well as kratom and other kind of things that mimic it, are an impediment to recovery. You have no business having it. So you're not to have any medical marijuana card or kratom or any other things that can mimic those. You'll be released today, and you report in person to the probation department meeting. If your dad's at Mr. Kurt's office, he can come out, pick you up, and get you up to the probation department. Now, again, this is your last chance, Mr. Smith, and you know, I'm getting this only because we want to get child support paid, and I'm going to give you just one more chance. But if you end up getting arrested again or whatever, yeah, you know, it'll be prison, and I'll give you a full 18 months because it's your third time around, fourth time around, and you know, if I see you again, yeah, I can assure you I'll be tired of dealing with you as is everyone else. All right, is there anything further, counsel? All right, thank you. All right, Roger Gruber, we're ready for him. All right, Ben, are we on record?
Yes, sir.
No, he's muted. All right, I'm going to assume we're on record, Ben.
Yes.
I know we're recording on Zoom. Case number, well, there are two cases here. Case number 18, CR241, 19 CR010, both State of Ohio versus Roger Gruber. You're Roger Gruber, appearing there from the jail. Yes. All right, this hearing being conducted by Zoom. Mr. Gruber's attorney is Dennis Kirk. He's appearing from his office by Zoom, and Mrs. Collins on behalf of the state, her office. The defendant was convicted in each case of aggravated possession of methamphetamine, 53 felony, was placed on community control on February the 15th, 2019. He had a current violation, and his community control was continued on August 13th, 2021. His notification filed on November 12th by the probation department, and Mrs. Kelly and Sandra Kelly is also appearing in the probation department on this Zoom screen. Rule 2 alleged the defendant failed to report probation since July 19th of 2021. And then Rule 3 that he listed an address of Greenfield as his place of residence in the probation department, but when he was in county court, apparently listed enforcement's address, so he failed to keep it informed of his residence. And Rule 15, he's failed to make any payments for fines and costs, balance of 671. And in Rule 28, he's provided no documentation of attending or completing any treatment and or aftercare. So those are the allegations. Mr. Kirk, you've had an opportunity to consult with your client regarding these alleged violations. I have, Your Honor. Okay. And are you and your client both agreeing to conduct this hearing by Zoom rather than a personal appearance in front of the court? Yes, we are. You're all right with that, Mr. Gruber?
Yes, Your Honor.
All right. Now, Mr. Gruber, if you do need to speak to Mr. Kirk during this hearing, just tell me. I can put you and him into a breakout room. It'll be just the two of you talking. No one else will be able to see you or hear you, okay? All right. Now, Mr. Kirk, does the defendant wish to have a hearing, or is he going to be making admissions?
I did advise him of his right to a hearing. He does wish to waive hearing and admit to rule violations of 2, 15, and 20A, and that he would deny Rule 3.
All right, is the address. All right, Mrs. Collins?
Fine, the state participants that one with the admissions to the others.
All right. Okay, Mr. Gruber, you have the right to have a hearing on this matter in which the state's required to present evidence that proves to the court's satisfaction you committed these violations. You have a right to have your attorney cross-examine the witnesses the state presents. You have a right to present evidence on your own behalf and to testify on your own behalf, although you're not required to, and no one can hold anything against you. No. In any event that you are found to have violated these conditions, whether you admit to them or they're proven by evidence, I can do one of three things. I can continue the same conditions previously or additional conditions that they were appropriate, including extending the term of your supervision up to 5 years. Or the third, the most serious, is I can revoke your community control, sentence you to prison for 12 months on each charge for a total of 24 months if it were to be served consecutively, plus fine you $2,500 on each charge. Do you understand the charges? Do you understand the consequences if you admit to these violations? Has anyone threatened you or promised you anything to get you to admit to these violations? All right, then do you admit the violations of Rule 215 and 20A as filed in the notification on November 12th? All right. All right. Anything from the state or the probation department regarding this decision?
Yes, Your Honor, at this time, the state would request the defendant's community control be revoked in both cases and that he be sentenced to a term of incarceration. We would note that he previously had a felony here back in 2007 and was given probation. He violated that probation as well and was sentenced to prison. He was told twice that these were his last chances in the 18 CR 241 case, both at his sentencing and at his violation in August. He was then given community control also in the 19 case. He has done nothing to be compliant with community control. I'm confident that he's going to say he has a drug problem. He probably does. He admitted to using meth on November the 12th of 2021. But if he had this problem, he's had since 2018 to take advantage of the resources of the probation department and address it. So based on all of that, we would ask the court to revoke his community control and sentence him to prison. I would also note that he's previously had treatment in this case. He was at the Massey House, which is why he wasn't, that was his one last chance before, because he was testing positive during his pretrial supervision for meth, coke, and marijuana. Thank you.
Mr. Kirk? Thank you, Your Honor. I do not know that I handled the original case, but I did handle the August sentencing, I did not note in my notes last chance, and I usually do, but in any case, my client actually asked me not to extend community control, but to see if STAR program or another treatment would be appropriate as opposed to letting him back out, because he does report a substance abuse problem. He states that he met with Sandy Kelly, who indicated that STAR would be a good option. That's just what he's telling me anyway. So in this case, I would ask that community control be continued, however, with either STAR or an appropriate residential treatment. He told me that he's finally wised up to the problems that he's facing. He said, if I get out right now, I'll use. So if I could get to treatment and remain here until a bed is available, that would be best for me, is what he stated to me. So I would ask for the opportunity for one last chance here with a STAR bed or a residential treatment bed as a viable option. Thank you.
Gruber, anything you'd like to say?
Thank you. Again, Your Honor, if I can have permission to speak freely.
Go ahead.
Now that the cloud is lifted, I realize I do have a backbone. I get out, just to get back to what I was doing. I do need treatment. Put me in prison just there's as much in there as there is in the streets. So all due respect, I have completed every program that I've done. And I will listen to.
When did you complete the Massey House?
I can't remember the exact date, but I had a year clean after I graduated, and it does work. I know it works.
Well, apparently not, you're back. I guess I'm questioning what's going to be different this time. Cloud lifted the last time after you'd been to the Massey House, but here we are again.
Well, my worst problem is Greenfield.
Well, I'm sure that presents lots of temptations, but I have no reports of anybody holding you down and forcing you to take drugs against your will. You know, it's just a question of, and you said you stayed clean for a year, but yet, you know, you didn't do what you're supposed to do. I had you just back here in August, less than, 3 months ago, for a violation, and I continued. And I told you what to do, and yet you didn't do anything I told you to. Well, I mean, you may have done some of it, but, you know, here you are back, you know, failing to report, failing to go to treatment, and, you know, you made no effort to get any treatment after you were in court on August the 13th, or August the 11th. Is that right?
I did, but my cousin actually works for Massey House now, so I fear it would conflict with.
Well, I mean, okay. All right. Anything else from council?
Yeah.
All right, well, the court's going to find then that, Mr. Brewer, that, you know, you are not amenable to bid control. You've been in front of the court here in August, just less than 3 months ago. You've not taken any steps to get treatment. You're not in a treatment program. You're not reporting, and you're just not showing any determination to do anything to help yourself. So it's a judgment in order of court that your conviction will be revoked in each case, and will be. And Ben, can you give me the jail time credit there? I have you on mute, so you'll have to come up to the screen. But in case number 18, CR 41, you're sentenced to a term of 9 months. In case number 19, CR 10, sentenced to 9 months. Those will be served consecutively to each other since they were committed as more than one course of conduct, and the criminal history is such that one single sentence will not accurately reflect the seriousness of the offense, nor adequately protect the public. Yeah, did you go time credit there, Ben?
Yes,
You
Judge.
need to unmute.
$23 days on the 19 case, 24 days on the 18 case.
How many on the 18?
23 on the 19 and 24 on the 18.
All right, thank you. All right, so you'll be given credit for 23 days on the 19 CR 10 case and 24 days in the 18 case. Now, upon completion of these cases, it is possible that the adult parole authority will place you under post-release control for a period of up to 3 years. They don't have to, but they can if they do. Will be supervised on the conditions they set, and if they determine that you're going to comply, they can return you to prison, making sure a additional period of up to 9 months for any one violation of a maximum of half of the prison term, which is the same 9 months as your term is 18 months. Now, if you commit a new felony while under post-release control, then the judge in the new case could sentence you to an additional period for committing that offense while under post-release control. In this case, 1 year, whatever time will be left on that 3 years of post-release control, whichever is greater. that occurred that had to be served in the second minute sentence in the case. So order to pay the court costs, which judge grant execution order. If you fail to do that, then the court can allow you to do community service while you're in prison, but after you get out of prison in this county, and we give you credit for each hour you work in an hourly rate set by the court. Each hour you work, reduce your judgment by that amount until paid in full. All right, is there anything further, counsel?
No, Your Honor.
Your Honor.